Justice emanates from the people and shall be administered in the name of the Republic by the judiciary, which shall be independent and subject only to this Constitution. That's in Article 125 of the 1992 Constitution. There's a clause 2, and here's what it says. Citizens may exercise popular participation in the administration of justice. How exactly are citizens able to participate in the administration of justice? We answered that question this afternoon. We are privileged to be hosting judges of the Superior Courts. I'm Samson Ladia Nyanine. This is the law. It is your help law. It is your legal light. We ride back. Welcome back. This is the law. It is your help law and it is your legal light. We're talking about reforming the jury system. And we're privileged to have in the studio Her Ladyship Justice Ifya Sewa Asariboche, Justice of the Court of Appeal, and Her Ladyship Justice Lydia Osei-Mafo, Justice of the Court of Appeal. Thank you so very much for making time to join us this afternoon.
Thank you so much. Welcome. It's a pleasure.
Great. So I began by reading from Article 125 of the Constitution, which says that justice emanates from the people. And then it also suggests that the people have the opportunity to take part in the administration of justice. What does the Constitution mean by this?
Right, to say that justice first emanates from the people is for us to understand the basics, that we the people, I think Article 1, we the people. So we are the people who give justice the power, and everybody else gets the power from whatever constitution or legislation because of what we the people did. And regarding citizens' participation, jury trials is one of them. For
Jury
us,
trials
is one of them. For us to be able to determine when the offense is a very serious offense, to make a determination or to contribute to a determination of the guilt or otherwise of the accused person. And in addition to that, you'll be looking at Article 19 as well.
Right.
That is also one of the parts of the legal framework.
Great. So, my lady, people can participate in the administration of justice. That will sound to people as really rare, because all they are familiar with is that a case comes to court and there's a judge, and the judge determines what it happens. Or it comes before a panel. You are the Court of Appeal, so a panel of 3. It goes to the Supreme Court. There are 5, there are 7, there could be 9. They don't see ordinary citizens participating. So this will be strange to some people.
Very well. I think the rationale behind is that these are ordinary people who live in the community where the accused person and the complainant or the victim live. And their perspective of how they see things and perceive things is what is informing the reason why they should be part of it. So that it's not just legalistic point of view, but what would the ordinary people in the society look at the evidence, the facts? And so that is the reason why the lawmakers brought in ordinary people who live in the community. So from the perspective of the victims and their people, and from the accused person and his people, we have a full representation. And so when the decision is made, then people will understand that this is not too legalistic. It is from the people, from whom and how they see the whole thing.
Right. The question of being able to participate as a juror. Who is a juror, my lady?
A juror is one of 7 ordinary people who would be called upon to assess the evidence on the facts with the judge, directing them on the law. such that the verdict is given by the jurors as to whether the person is guilty or not guilty. The jurors are judges of fact. The judges are judges of law.
A juror is one of 7. And my lady was stressing, if you were listening, they are judges of fact. Why one of 7? What does that mean?
Okay, so we have 7 people, like I said initially, from the community, who more or less, if you look at the qualification, they do not have legal minds to look at things from the perspective of legal people. So they would look at it. And because there's a vote at the end of the day, that if it is this offense, this number of people who would vote for guilt should be this, or not for guilt should be this. And so we have 7 people, so that if it's 4 against or 5 against 2 or 6 against 1, then we have that number. I think it is also to help us, everybody would have a way of looking at the evidence from their individual perspectives, and then they will be able to, so when the majority agree that this is it, then that should be it, and that is the mind of the majority or the community.
My lady, how do we come to constitute these 7 people?
First of all, we deal with jury lists.
Jury lists.
Twice a year, in May and in November, the jury lists are made from certain qualified people. And even then, outside of May and November, where we think that our jury lists are depleted, the Chief Justice may order that jury lists be made. Now, once we have a number of jurors, the next step is for the jurors, when the accused person is put before court, for the jurors to be empaneled. So it's a kind of balloting. And apart from the balloting, the accused person also gets the chance to challenge whether they would like for this juror to be there or not. There's different kinds of challenges. I'm sure the students are really paying rapt attention. There should be 3 challenges which are peremptory. That is, you don't have to give any reasons. And then 3 challenges for cause. For challenges for cause, there is no limit for you to give reasons why you do not think such a person should be a juror. So it's a kind of balloting, and after the ballot, after all the challenges are dealt with, you settle on 7 men and women, men or women, and or women.
My lady kept referring to community, that this juror come from within the community. There's someone who is watching, and before today, when we put up the flyer, ask the question, how can I become a juror?
Very well. You, under our law, the Act 30, that is the Criminal and Other Offences Procedure Act, that regulates how we try our cases, criminal cases. When we look at Section 504, we'll give you some qualification, and it says that subject to Section 207 and 208, a person between the ages of 25 and 60 years who is resident in the Republic and who can understand English language is liable to serve as a juror. So you have to be between the ages of 25 and 60 to qualify. In addition to that, you have to be a resident of the Republic. And beyond that, you'd also have to understand the English language. Then, when I read, it says subject to Section 207 and 208, and the exceptions are here. If the person doesn't fall within any of these, then the person would qualify, and I would want it a tall list.
Right.
And
so we will go through the list first. My lady will help us to go through the list first. And when we are done, one of the questions that already came up even before we started is what you just mentioned. First, you say you must be in the community, you must be Ghanaian, and you must be 25 up to 60. And you must speak English. I'm in a community, I observe everything. I feel I can participate in this process, but I can't speak English. We'll come to that. So who is qualified, my lady, who is qualified to be a juror?
Anyone who is 25 to 60 and can understand the English language and resident in Ghana, not necessarily even Ghanaian. You are resident in Ghana. Once you are not exempt, you are liable to serve as a juror.
Okay.
So, do you want me to go through the exceptions?
Yes.
The exemptions are 207. The president, the vice president, the speaker, and members of parliament are exempt. Justices of the Superior Court of Judicature, judges and magistrates of the lower courts, coroners and deputy coroners are exempt. Legal practitioners in actual practice and other court officers, registered medical practitioners and dentists in actual practice, registered pharmacists in actual practice, prison officers and warders, police officers, officers and members of the armed forces on full pay, public officers other than those engaged in clerical duties, employed in the medical, post and telecommunications, customs, excise and preventive service, or under the Ghana Ports and Harbours Authority, persons actually officiating as priests or ministers of their respective religions, schoolmasters actually engaged in teaching school, persons employed in a public electric telegraph office or in electric power station, diplomatic and other consular representatives, and the salaried functionaries of foreign governments, editors of daily newspapers, and any other persons exempted by the Chief Justice. So if you do not fall under any of these categories, you are liable to serve as a juror if you are between the ages of 25 and 60 and you are resident in the Republic and can understand the English language.
So the following, the people you have listed are the persons who are exempt from liabilities to serve as jurors.
Correct.
The editor of this, the Joy Newsroom, is watching and listening now and doesn't understand why he cannot be a juror. Why?
So that's the thing. The whole thing where we are here, if you look at the list, and I was intrigued when I looked at say public officers other than those engaged in clerical duties. That means all public officers other than, so those who are engaged in clerical duties are those who are supposed to be, you know, the role they play there. And it is something that has taken away virtually almost everybody. But when you look at the law, it doesn't say that it's only the public sector's workers that are needed. It's a citizen or person that is resident in the country. So that means we can rope in people who qualify, who are within the age bracket, who are resident, who can also speak English. And if you look at 208, it also says that a person convicted of treason or felony or an offense involving dishonesty, all these people are not. So if you are not in this category, of course, and you are in the private sector, you are supposed to, you are liable to be a part of the...
It's understandable that police officers are exempt, that the president is exempt, members of parliament are exempt, judges, magistrates, legal practitioners in actual practice. But why do we exempt the schoolmasters? Why are we exempting call them the priests?
You see, Samson, let's also understand the historical perspective. This legislation was passed in 1960. at a time when our literate population was really very low. So if we were to co-opt all the teachers to do jury duty in the community, we probably would be taking away almost every literate person.
Right.
And so on. I am thinking and I'm hoping, I've been saying this a long time, that we would soon have some kind of amendment or a reenactment of our procedural rules. Why do I say so? The fact of life is that a lot of things have changed, even with professions. I'll look for, just to give a loose example, persons employed in public electric telegraph office or in, like that would be, in those days it used to be post and telecommunications,
right?
P&T. Today, P&T, people who are involved in post and telecommunications, they are very few. And internet has taken over their work.
That's right.
The post office is almost non-existent. We used to have these telephonists. They no longer exist. I don't know whether they do, but I don't think they do. It's time for us to have another look at the exemptions. Now, the schoolmasters in actual practice, actually teaching school, we do not want to take the teachers out of the classroom. So if you have a schoolmaster who is in administration at the GES office, that person can be called upon to do jury duty. It says medical practitioners in actual practice. If you are a doctor and you are doing something else, such as you are in trade or business, you can't be co-opted. Same for pharmacists. A pharmacist who is in actual practice, what does it mean? It means that if you're a pharmacist and you are not practicing as a pharmacist, but you have gone on to do something else, you can be. Now, schoolmasters, the other question you would ask, would schoolmasters include university lecturers? I don't think so.
Okay.
I don't think so. I think that schoolmasters...
So there's a good pool to draw from.
There should be a good pool.
Right.
I think that hitherto we have been limiting ourselves, but looking at the legislation, there should be a good pool. But we need to also have the employers understand that it's time for us to call on anyone to be a juror. Right.
My Lady Osemafu, why are we insisting that you should speak English?
Where is that?
When this is supposed to be a community thing, so that your peers can help to determine that you have actually done wrong.
I think that, one, the law says so. So we would work with that. Ideally, if it's in different languages, I can almost foresee the difficulty of the people to understanding. For example, if the 7 people are guarded, and then this one is speaking Dangbe, that is speaking Ewe, that is also speaking some, 7 of them are speaking different language. Can we afford to have that luxury of bringing different interpreters so that when the evidence is given, then the person goes about interpreting after that, then we go here. Even now, with my experience as a jury trial judge, if we have more than 3 accused persons speaking different languages, it's a challenge because it impedes the expeditious trial of the matter. Because we would have to have a Hausa interpreter, a Twi interpreter, an Ewe interpreter, all of them interpreting one person's language. So I can imagine the difficulty. I think the lawmakers thought it wise that should we allow any language, then as soon as the person is selected, you are obliged to provide an interpreter. And I think that will not go well with the expeditious trial of the matter.
Right.
And just a little addition. English is our official language. I think it is not only in this legislation that the requisite ability to understand English is there. It's the same also for people who are qualified to be independent witnesses. You must understand the language, which is the official language, which is English. So I always say that if you have an independent witness showing up, insisting that I want to speak Twi or whatever, already the case is a little weak. So it is our official language. The entire proceedings will be carried on in English, and they should be able to understand not only what the witnesses are saying, but also all the things that the lawyers are saying to be able to make a decision.
Right. If you're just joining us, we are discussing jury trials, how to reform the jury system, and we will get to the point where reform is being suggested and something new that appears to be happening to the system. But already you are hearing my lady suggest some reform already as we discussed, but we'll get to that point. How important is the role of the jury in the delivery of the criminal justice system in Ghana?
Very well. When we started, I said they come from the community.
Right.
And so it's important that the perspective of how they do their things, culturally, religiously, it's also brought on board. And so it's important that the ordinary citizen also gets to be part of it. In other jurisdictions, jury trial, those who have it, it's not only restricted to criminal trials. It's restricted to, it also includes civil matters. But in our jurisdiction, it is restricted to some, not even all, criminal trials. It got to do with when the punishment is death or life imprisonment. In that case, let not the decision be made only by one person who looks at it from just one. Probably, if the evidence is that somebody got so angry and then killed another person, the circumstances of how the incident happened could be appreciated better by the ordinary people in the society where both of them, that is the victim and the accused persons, are. So when they do it well, it is believed that their judgment should be very objective to help us, so that it's not just the judge who thinks only the law and all that. The law will be there. However, what would the society feel or think about this scenario if it had happened? So I think ideally, if we were doing it well, it would have helped for the citizen to also make an input into whether somebody should be sentenced to death and be killed or not.
My lady, how do we explain the decision to limit the participation of the members of the community to only certain cases and not all?
Well, it is a creature of the Constitution. Article 19.2 says that a person charged with a criminal offense shall, in the case of an offense other than high treason or treason, the punishment for which is death or imprisonment for life, be tried by a judge and jury. Then also there is another class of offenses, that is first-degree felonies, which may not be punishable by death or imprisonment, like rape. Rape is only punishable by 5 to 25 years, but because the class of the offense is first-degree felony, the law is that it is triable by a judge and jury. So there are also other classes of offenses, even other outside the Act 29, the Criminal Offences Act, which are also classified as first-degree felonies, which are triable on indictment by a judge and jury. For instance, terrorism, anything related to terrorism, terrorist financing, triable by a judge and jury. Another currency, making fake currencies. It's actually a first-degree felony, triable by a judge and jury. So if you have those, because the law says it is first-degree felony or it is punishable by death or life imprisonment, it is triable by a judge and jury because the law says so.
And if I would add, if you look at the law, it says other enactments. So if the law says first-degree felony and that particular enactment states the mode within which we should try it, then of course we would try it summarily. But if it doesn't and it just says first-degree felony, then of course we have to try.
For the benefit of our audience, you just mentioned if the law says you should try it summarily, that's what you would do. What's the difference? Summary and jury trial?
Very well. Summary trials got to do with only the judge who sits and listens to the evidence of the prosecution and the defense and makes a decision. But when we come to jury trial, the judge sits with the 7 people who are the ordinary people, like selected according to certain criteria. At the end of the trial, their decision is binding on the judge. So I may look at the evidence, the defense from a certain point of view, and in my opinion, probably the guy is not guilty or is guilty, but the jury has the final say to say that this evidence, the person is not guilty. So that sometimes we hear some cases, oh, they have hung jury. It means that even they themselves didn't agree as to who is guilty concisely according to the number of jurors that are supposed to be voting. So that is the thing. Otherwise, a judge generally in almost all our offenses is summary trial. And if the law says summary trial, as soon as it is first degree without stating what mode of trial, then it is indictable. Indictable means also sitting with the jury or assessors.
Right. Now, having discovered how important it is to include the people, ordinary people in the community, in the justice delivery process, the question to ask is, what do they really know about the justice process that a judge needs their help?
It is not a question of knowing about the justice process. It is a question about knowing their community and how they think and do things.
If someone is accused of murder, my lady, and they have really killed someone.
Well, it's a homicide, but as to whether it is a murder is a matter for the jury to determine.
It's for the jury
to determine
that as a matter of fact. It's actually not a decision of the judge.
No. What the judge, we are all listening to the evidence. When we are done, the judge will do a summing up and give them directions on points of law. By law, this is how we do it. However, looking at it, I always use provocation as an example. If there has been a homicide, meaning that someone is dead, and the person says that I was so angry that when I got to the scene and I saw him, excuse me, maybe having an affair with my wife, I didn't think straight, I just killed him. Now, in the community, the question the jurors would have to be determining would be, is it reasonable to be so angry just because somebody is having an affair with your wife or not? That is for them what to determine. In some communities, they say that people actually host guests by letting their wives go into them. So for them, maybe it may not even be an issue. But for communities where we are very territorial and we want to make sure that people should be with their wives alone, that might be an issue. And that is how the jurors are supposed to help make the decision, looking at their community values. Would the action of the accused person be reasonable or not? And that is how they know a lot about their community.
Is that to suggest that if the community people who constitute the jury take the view that a particular, offense is excusable, the judge will be bound?
Yes, please. That's it. You are bound.
You cannot tell them that what you are telling me is not what we are supposed to take.
No, you don't have that luxury of saying that your decision is wrong.
The job of a judge must be very difficult because in the end, it's the judge we all blame, particularly when it doesn't go in our favor.
Exactly. So at the beginning of the trial, every jury trial, there's a direction by the judge. The lawyers from both sides also would address the jury as to what to look out for. And then the judge would also direct you. There are certain stage, when we get to a certain stage of the trial, and it becomes necessary, if it's a question of law, we excuse the jury. From the onset, the judge would inform the jurors that if there is any question of law that is raised, then that decision is for the judge to make. And in which case, if it's a question as to admission of certain caution statements, then somebody raises objection to it, the judge would excuse the jury and make a finding. We call it mini trial, conduct a mini trial to see if the statement was taken voluntarily. And when that decision is made, then the people are brought back to join the main trial. At the end of the trial, then the judge also sums up. From the beginning, I will tell you, pay attention to the evidence. The evidence means the oral testimony of the witnesses, the exhibits they will bring. Now we can see some of the exhibits that can even be played, that can audio come in the form of audio, video, and all that. They are all played for them to see the evidence. So at the end of the trial, the judge, after the lawyers have also addressed the jury, the judge would sum up the evidence of each person that entered the room, what it means, and then leave it to them. Then on the law, you know, we would have to establish the elements of each. The judge would tell them these are the elements from the legalistic point of view.
Right.
What evidence did you hear which will go to confirm this particular element? Then we leave it for them to go and deliberate. The evidence that has been brought also would be available for them to also look at it. I would want you to refresh your memory better. So I leave all the exhibits are there. Please go have a look at it again before you come with your verdict. Because we don't want to, it's so cumbersome to start and end a jury trial. So if we get the verdict wrong and we have to go over again, it's not funny. And so sometimes it's a challenge for the judge. I wish it had gone this way, because if you look at the evidence, so clear. But the people will come back and say, no, we don't think the person is guilty. You know, when it gets to that place, I don't know.
My lady, I was reading Justice Dennis Ajay's thesis, in which it's a 2014 one that he did, in which he spoke about the weaknesses of the jury system. And he selected about 3 cases that he had done, which were all overturned on appeal.
Exactly.
And he used that as the evidence to show that the jury can get it wrong.
Yeah.
Are we thinking about that?
Personally, you know from my background that I have a criminal practice background.
Right.
I have personally dealt with cases that I felt we were not able to, I don't know whether it was the communication or the appreciation, but I have personally seen cases where you would appreciate that the perspective of the jury is different. I have seen one brother kill the other in the presence of their mother, who only spent, she was the only witness, unfortunately, that we needed to call. And her first statement, I knew, would undermine the entire case of the prosecution. I was a prosecutor then. Because the first thing she said is, well, I only have 2 children, and one has killed the other. Whatever happens, the one left, no matter how bad, is the one I have left. Then she goes on to tell the court what happened. The jury returned a verdict of not guilty. The direction given was a murder direction and a manslaughter direction. They returned a verdict of not guilty. I'm sure everybody was just thinking, which mother goes to testify against one son when that's the only one left and she'll be left childless, so to speak. That is unfortunately the situation. And there are also others. For a long time, we have had problems with selecting jurors because we had such a small pool to select from.
Right.
But now that we are such a literate population, we have so improved in our literacy that the ability to appreciate the English language and be between the ages of 25 and 60 and not be exempt under any of the clauses in 207 makes it clear that we can now get a much larger pool to choose from. Yes, we had a lot of seats of its own destruction, but with the improvement, I think we can get better numbers, and then we can work with it.
We'll get to the subject of how to expand the pool to get more people to do jury duties. But before we get there, you are still here on the law. This is your legal light. It is your health law. And we are learning on jury trials, how to become a juror and to assist the court or to assist the state in trials. And here in the studio, Her Ladyship, Justice Ifia Sewa Sariboche and Lydia Osei Mafo. They are both justices of the Court of Appeal, and they are very experienced in this area, sharing their knowledge and helping us to understand so that we as citizens and we as residents in our various communities can also make up our minds and try to assist in the process. Now, in the selection process, you say there are 2 seasons within which you do the selection. And there are times you could even create extra periods to do the selection. You do it in May, and then in November. How is it done? How do I get to know, and how do I offer myself?
You don't offer yourself. We call you.
Okay.
So what happens will be that the registrar of the court, it starts from the magistrates. Because it is something which is jurisdictional based, district based, it is the magistrates who form the jury list. Now, the new thing now is that instead of just writing to civil and public service offices and asking them to nominate people for us, the new thing is that we can call anyone in any institution. The most recent improvement, and it started from the central region, was for an application to be made, actually ex parte, for institutions to submit their staff lists and everybody's job schedule. Now, when those staff lists were submitted and they came from certain institutions, they were required to submit their staff lists. And then the service chose 160 of them in the central region alone.
Okay.
So in such a case, once they are called upon to do jury duty, unless they show up at the magistracy and show cause why they should not, they are compelled to act as jurors for the session. And we'll discuss the session, I hope.
Okay.
So, because you see, we used to have this situation where we've had jurors for years going and coming. It is no longer the regard. It's not happening anymore. What we are going to do is to make jury lists twice a year or more if we need them.
All right.
And then we go on from there. So we are going to replicate it all over the country. Institutions will be receiving notifications that they are supposed to submit their staff lists. And please, it would be borderline criminal to submit your staff list and delete some. Submit all your staff lists with their job schedules, and we will select whatever number we need, and then we have our pool of jurors, out of whom we will do the balloting.
These institutions include
private enterprises. Yes.
Enterprises?
Yes.
And they are under compulsion of law?
Yes.
To submit the lists?
Yes. Yes. And it is
allow their workers to come to the court and to assist the state?
Yes. Yes. Now, the good news is that this is not going to be the interminable duty that we used to have. Years ago, we used to have what was known as criminal sessions or criminal assizes. It works very well because it gives a certain period for doing the criminal cases. The people come in, they sit within the session, sometimes a week, sometimes 2 weeks, from day to day, all day. One case is pending. Once they are done, day to day, all day, 5 days, 10 days, the case is disposed of. The jurors are discharged. We call another set.
Oh, really?
Yes.
Okay, so you are learning first time on the law that this is the new thing that is happening. Is this part of the leading justice reform that Her Ladyship, the Chief Justice, is introducing?
Definitely, it is. Because the old system as we had it, we had some of them who had served for 10 years, 5 years, 2 years. You know, so it became something more or less their side job. They call it, if the medical people look kind of, you know. So the painful thing was that you get everybody, the lawyers come in, the witnesses come in, and then 1 or 2 of the jurors will not show up. And then they will be marked. That day, about 5 of them are present. Over the period, no work is done. They would want to be paid some allowance or some TNT. So we had piled, and it got to a point that then they said the service is not paying us allowance, and therefore we are on strike, which is not legal. You know, to avoid this, then my lady said, no, we can't go this way. You will not work, and yet if I owe you to, then you sit and say that you are on strike. And therefore, let's scrap the old system where people had the laxity of calling themselves at funerals and places that I am a juror. No, this time we would do the case within a certain period. Everybody knows. I do a case completion plan from the onset. And so you are not just there, you are coming and then, no. We are certain that this particular day, we are starting this evidence. And the evidence of PW1 is this person. Meanwhile, his statement or her statement is already before the court and with all the lawyers and everybody. So that if you don't come, now we are going to apply sanctions to you. Hitherto, we were treating them with soft gloves. Now, if you don't come, we would apply the law. We would sanction you. We will fine you. If a witness doesn't come under the law, we have a way of compelling their attendance. If they don't show up, we still can fine them. So we are going to put up all these things to work such that when you are invited, even lawyers are not spared. If you are a lawyer, you are supposed to show up. I've given you date and time, and you are supposed to show up, and you don't, and you can be hauled before the appropriate authority to be sanctioned. Prisoners are not spared. Police are also not spared. Everybody should be on deck, such that now that we are bringing in everybody, you know, the private people, what they hate is that you take away my staff and forever. No, they can't.
So now this is part of, actually it's an attraction.
Yes.
That I know that I'm going to do jury duties, and I know I have a week set aside or two. Exactly. I will go through it, there's a daily trial, and it's over. I'm done.
Yes.
Right.
And you are not going to be empaneled for any other case again.
Okay.
That's it. We are done with you. Unless probably another session, your name gets onto the list. Otherwise, the particular session that we are doing, we are
Why is it taking us this long to take this decision? Because the juror have held the system to ransom for so long.
Samson, I started work in 96. In 96, we had criminal sessions. And at that time, we would open the session. It used to be a very interesting, it was a huge ceremony. That ceremony would show that the session was opening. And it was assizes. Even our grandparents had a name for it, Asisi. And then we would start and finish from day to day, all day. This thing about having jurors carrying over into a new legal year, I don't know how it came about. I saw it maybe 15 years ago. And the whole idea of having a juror, serving as a juror for 10, 15 years, actually defeats the purpose of a jury trial. Because if anybody who sits in a case or sits in cases for that long would have even qualified as a lawyer, if you ask me.
Right.
They are not the clean slate that we need them to be. So 10 years, 5 years, some of them are involved in several cases. You want to adjourn a case to a certain date, and they say that I have another case, same as lawyers are doing. Now, one juror, the 7 jurors would only be involved in one case, in one court at a time. When they are done from day to day, all day, you hear the witnesses 2, 3 a day, whatever the court can accommodate, day to day, all day, in few days. A lot of the very serious cases, the homicides, they don't have a lot of witnesses. If you will notice, many of them do not have more than 10 witnesses, 5, and then we'll be done. So long as the lawyers, everybody has to work, and everybody has to comply.
Now let me make a confession where I'm smiling as you speak. I'm just hearing my lady speak in her court. strict. Strict. If she gives you the times and the days and you and the specific time to do your work, and you come and you are giving excuses, she will not take it. But if you want some water, she'll serve you very good water to drink. Now, there must be some, as it were, incentive for somebody who is, you know, wanting to become, to participate and to help, so to speak. Elsewhere, people find it a certain credit in the UK and the US to want to be part, to be selected to do jury job. They feel honored.
Exactly.
What about it here that should be that kind of attraction for people to, you know, a company to submit their staff list and they to jubilate that there's a possibility that they would do this job?
It's some allowance for certain mileage. Ordinarily, within, I think, 4 miles radius of the court presence, we're entitled to some allowance. But I don't think we're really sticking to that. We were just paying them certain allowance for showing up. The allowance will be there. In addition to that, we will provide them with meals, some water, and then for them to do. One thing citizens would have to appreciate is that when we are lambasting the court for delaying, then you are called upon to come and play a certain role. You don't expect also to receive something handsome there. You have to see it as a duty to offer to your mother Ghana, to the country, for it to work and the system to work, and not to be expecting anything huge, some ransom from the court. That I'm sure would disappoint you. But some allowance, some reasonable allowance should work.
They are impaneled for capital offenses, and I'm going to be the one responsible for somebody going in for life. That's, some people will say, I don't like the idea. Some Christians or Muslims will say, it's my job to, I'm the one sending the person to jail.
You see, once somebody is put before the magistrate or the person is listed, if the person has certain religious beliefs, which makes it impossible for them to be able to make a certain decision, they ought to say so.
Okay.
But then, in fact, a lot of capital offenses, there's been the amendment to the Criminal Offences Act, so we don't have death penalties for a lot of offenses. I think the death penalty offenses have been whittled down to 3 or so.
You mentioned rape a while ago.
No, death penalty would only be treason and high treason, currency offenses and terrorism. That's all. Not many.
Okay.
The rest, the murder, the rest of them, use of offensive weapon, those have all gone down to lifers. But then, yes, some people. But the other side of it, I always say that anybody who has done jury duty, who has experienced sitting in judgment of another citizen, would have learned a life lesson that no course can give. The fact that anger is not a good thing, the fact that human life is very fragile and people die very far easier than we imagine, that itself, and the fact that you are called upon to do the work judges do, you are qualified to do it. You've never been, you are not a criminal, because if you have been convicted of any offense involving dishonesty, you don't qualify.
That's right.
That in itself should tell you that you are no mean person, and it should be a self-actualization goal. If you
and you are also actually helping keep your society safe.
Yeah.
So that is an honorable job to do. I was going to ask this next question, but it's been implicitly answered in how fast the process will be and sessions, about measures that you're putting in place to ensure that the private sector participation does not disrupt business operations. That has been answered, I suppose.
Yes. And I think it is of great importance for us to emphasize, for the benefit of the judges, the lawyers, and everybody else, that once we have brought private practitioners and private enterprise participants into this system, we cannot afford to be indolent and waste their time. So it has to be day to day, all day, until the trial is done. and then they can be discharged and we can move on.
Right. Do people who are selected for this role, are they giving some sensitization, some training of sorts, so they can be confident in what they have to do? There are people who have not been in court before, and when they step in the courtroom, you can tell there is this fear.
Yes, yes. We've started the sensitization. Started with Cape Coast on Wednesday.
Okay.
We had all 160 jurors who are listed for the Central Region. We also had members of the bar, the Office of the Attorney General, legal aid. And it's important to look at the role that private practitioners have to play.
All right.
Because we all know that lawyers in legal aid are not many. The judges can assign cases to private practitioners to deal with. And then also, going forward, we are doing the same for almost every region. The police, prisons, so that they know that they're supposed to present accused persons. We are also going to explain to them what the sanctions would be. Going forward from this year, any police investigator who fails to present the accused person or who fails to present a witness who is listed to testify is liable to be reported and dealt with by the appropriate authority. The same for the lawyers. We are going to deal with them in accordance with Regulation 98 of the Professional Conduct and Etiquette Rules. Any lawyer who knows he's supposed to be in court and fails to do so will be dealt with in accordance with law. Same for everybody else. So the judges also should be attentive to the fact that this could be a ground for incompetence on their part. It's time for us to move on from this interminable jury trials. It's wrong.
My lady, that's serious.
Yes.
That a judge is thinking that this potentially could be a question of incompetence on their part, which means that could lead to their removal from being a judge.
That's the thing. But that also, there's a requirement that provides status of your trial within certain periods. So my lady is always on her neck asking for what cases you are doing, where has it reached, within what time are you going to finish it? So that if you have that in mind, and there's a session we have begun, you are doing this trial, and you can't lay back. All the others, there's a platform, everybody is complying, so you cannot be left out. Otherwise, you'll soon be shown. You know, it will be so obvious that wherever you are playing.
There's a whip system in the Leading Justice project.
Yes.
You know that we have two practice directions we are using now, three actually. The first practice direction on disclosures, the second practice direction on effective case completion strategies, and a third practice direction on jury trials. Now, another thing we are paying attention to is when the state will do the disclosures. This whole idea of presenting an accused person and now ordering disclosures is a thing of the past.
Okay.
The direction is that when you are filing the charges and you are before the court, file the disclosures even before the arraignment. If the person then wants to plead guilty, the person has enough information to determine whether they want to plead guilty or not.
There is a bit more that we will explain to you in part 2, the final part of this session, which is the reforming the jury system. And there's a lot more that we'll reveal to you in the next session. And we will also, as we always do, as you can see today, we didn't open the phone lines for you to join. We'll open the phone lines for you next week when there are ladies, Justices Ifia Sewa Sariboche and Lydia Osayemafo of the Court of Appeal join us to continue the final installment of this discussion on reforming the jury system. There's a lot more, and we shall give even further and better particulars to help private companies and so on to know your way around this system. Thank you so very much for making time to join us this afternoon. And 1 hour just came by like that, so fast. Thank you indeed for your time. It's the law, and it is your help law, it is your legal lights. I'm Samson Ladia Yanini. Join us again next week for the second installment.